to the first of our regular employment updates, highlighting what's happening and changing in relation to employment law and practice. In this episode, we will cover the developments after the Supreme Court decision on the definition of a woman, new neonatal care leave guidance, new rules for submitting tribunal claims and responses, and the proposed major reforms to immigration rules and the right to work in the UK. So firstly, that widely reported landmark decision where the Supreme Court held that a woman refers to a biological woman in relation to the Equality Act 2010. It must nevertheless be emphasised and remembered that transgender people are still protected from gender reassignment discrimination, perceived or associated direct discrimination, harassment or victimization related to the sex they identify with, and indirect sex discrimination if they suffer the same disadvantage as those with the sex they identify with, even though they do not share that biological sex. The new ruling has of course had significant implications for numerous day-to-day issues in the workplace and across wider society. One such area is the provision and use of single-sex toilets in changing rooms. New interim guidance on this from the Equality and Human Rights Commission emphasises that in workplaces it is compulsory to provide sufficient single-sex toilets as well as sufficient single-sex changing rooms and washing facilities where these are needed. Consequently, trans women should not be permitted to use women's facilities and trans men should not be permitted to use men's facilities, as to allow this would mean that they are no longer single-sex facilities. Where possible, mixed-sex toilet, washing or changing facilities in addition to single-sex facilities should be provided. There are different rules in relation to services that open to the public. It is not compulsory for such services to be provided on a single-sex basis or to have single-sex facilities. These can be single-sex if it is a proportionate means of achieving a legitimate aim and they meet the other conditions in the Equality Act. However, it could be indirect sex discrimination against women if the only provision is mixed sex. The Commission has also launched a public consultation on updating its code of practice for service providers, associations and those delivering public functions. Although there is no current suggestion that the Commission intends to conduct an equivalent consultation on its employment code of practice, it is likely that a court or tribunal would interpret provisions of that code in a similar way, especially in light of the interim guidance that we've already discussed. A new right to neonatal care leave and pay came into force this April, and Acas has recently published helpful new guidance which makes several best practice recommendations. For example, it encourages employers to allow family members or friends to notify them on behalf of the employee. And while on neonatal care leave, with permission from the parent, employers may find it easier to talk to such a person for updates. It also recommends that employers be flexible and understanding during the first 7 days when the employee is not yet entitled to take neonatal care leave, including considering compassionate leave, unpaid time off, and other leave rights. A new practice direction has set out the available methods for the presentation of claims and defences to these claims to the employment tribunals in England and Wales. It lists the methods a claim or response may be made and how to do so. In particular, employers should note that presenting a response will no longer be possible by email unless there is provable evidence that the online submission service is not working properly. And just as a reminder, in certain areas, solicitors and other professionals logging or responding to a single claim must do so online. And finally, the government plans to reform the rules around immigration, one of the aims of which is to reduce the number of migrant workers. The proposals set out in a recently published white paper include introducing new English language proficiency requirements across a broader range of immigration routes for both main applicants and their dependents, reforming the point-based system, particularly with the aim of reducing the reliance on immigration within certain sectors, reducing the number of eligible roles which may be sponsored on the skilled worker route, abolishing the immigration salary list under which minimum salary thresholds can be discounted and replacing it with a temporary sorted list, and increasing the immigration skills charge by 32%. An amendment paper to the Border, Security, Asylum and Immigration Bill also includes proposals to extend the necessity for right-to-work checks to include gig economy, casual and zero-hours workers. The impact of the proposed amendments is potentially far-reaching and would mean that employers will be legally required to carry out right-to-work checks and will be liable for any illegal working and any subsequent civil penalty in relation to any and all type of worker. We will keep track of developments for you. And that's it for this week. Watch out for our next video update. Have a look at our podcasts and blogs for more updates, practical advice, and commentary on topical issues.